Menteri Rang Bak Berim Kejela Dr. Mukul Sangma hak sinengkong ulap tha ke Sarkar MDA pakan Sangeh no ke jingle Politic bat ke Meghalaya Residence Safety and Security Act Mrssa kebatmu bantelaka me ke jingrung kertep ki bajela bat poiwer hapo kejela habai simbenta hak jingya tai hak jingkren ulat u Dr. Mukul ulaong baka Mrssa kedai kawai na kain babiang baha kabadon hakane ke perthai pantela kam me ke jingrung kerteng ki ba jela bat ki poiwer la manjor lang yaka da ke yingdor ba thau ain harengkat ke jingdon benta lang jongki kenhon ba pher hakis nem balalik no ulong ba ki babun kiri kenthop ke USA UK ki dangwat ya kilat kilenti kumno bantela kam ya ki poiwer namar bakimdon satya ya ka ain kum kene bat ulapan pau ya ke jingkwa bat kentu ya borok kentup ke sarkar pakan kin kongsan ya kene ke ain badan kam ke bawan ra na ke benta ke bit ke biang jong ke jela badula ong ban umdei ban yele politik ya kene unde menteri Rang Bak Berim ulak kendo ba ya kene ke ain la set hakaruli pja nadu usnem al hajar khat pra namar ula ong balada ya rai ban yele politik bat kene ke ain ke bakta ya ke baha kembet jong pai ba.
As I have mentioned, Meghalaya Residence Safety and Security Act. You look at its positive implication, the positive ramification in the overall approach to governance of the state by different authorities. You with me? By different authorities. It's not just the authorities at the highest level. Not only the authorities at the district level, but even at the community level, at the village level. This is the only act which has defined the traditional institutions. Please remember the other judgment pertaining to the judgment by the Honorable High Court then in respect to the issue of the recognition of the headman in respect of the High Court order issued by the Honorable Justice S.R. Sangeh. You see? So, this act has given a kind of legal mandate to the status of the traditional institutions. Okay? So, you can understand the magnitude of importance of this act. Based on this, nobody can now question. Nobody can question the existence and the authority of discharging their responsibilities and power thereof as per the mandate of the provision of the Constitution under the para 4 of the 6th rule of the Constitution. You see? So therefore, you have somehow legally mandated them to enforce the provision of the law, provision of the traditional customary laws and various other laws which are in consistence with the mandate of the provision of the Constitution in as far as the 6th schedule is concerned. So, therefore, in addition to that, you look at the various other application of the law. The application of law creates an involvement of both traditional institutions, the community, and also the state authorities, which includes the police and district authority. So, therefore, there is minimum scope for any complicity of any authorities under the government in order to dilute the application and mandate of the law. You understand? Because people themselves are involved. So it's a kind of law which was designed after having this exhaustive engagement, due diligence, and exhaustive over a period of time. It was not something which was done hurriedly. It was an offshoot of an exhaustive, long-drawn engagement, discussion, deliberation involving stakeholders, and having understood the actual, complexity of the problems which this act is intended to deal with. You see, you have lots of complexity when you talk about illegal immigration, when you talk of illegal immigration and the problem of influx, because the concern of the people is also to look at the demography of the state, how we can ensure that the very demography, the population structure and the demography structure, some or other, do not get over a period of time changed or diluted in a manner that gives reasons for the indigenous tribes to be more concerned about their future. So that's the idea.
Well,
And which is again very crucial for safety, security, and peace.
Well, Doctor, the Center has returned Mrsa's Amendment Bill 2020 to the state government to reconsider. What do you think about this?
I have said this before the August House today. Was it necessary to amend the Act? If they want to amend the Act, they have to look at the legislative jurisdiction of the state legislature vis-a-vis the constitutional provision. I have said that we have done a tightrope walking. We have explored the possibility of doing maximum in as far as the legislative jurisdiction of the state legislature is concerned under the mandate of the constitution of this great nation. You can't go beyond the legislative mandate of the constitution. And if we do anything which gets turned down because of that means we don't know how to legislate. We are proving that, okay, we are lawmakers though, but we don't know how to make law. When you don't know how to make law, it will be turned down. When you don't know how to make law inconsistent with the legislative jurisdiction of the state legislature, it will be turned down by the governor. Or it will be referred to the union government, as you have seen it. So it's a question of, whether the intent of the government was to play to the gallery, or did they have a serious intention to really protect the interests and address the concern of the people and the state? That is where the question lies. There has to be honesty. There has to be clear, honest intention to really do justice to the concern of the people of the state. This is exactly what we did, along with the involvement of all concerned, all the stakeholders.
Citizen first is our motto. We believe that our citizens need to be connected with government for faster and efficient service delivery. I am happy to announce that we are coming up with a dedicated CM helpline call center.